Contracts may be invalidated for several reasons, including unconscionability. In Chavarria v. Ralph's Grocery Company, we examine California's treatment of unconscionability in the context of an arbitration agreement. Zenia Chavarria applied for a position at Ralph's grocery store and was hired as a deli clerk. In order to submit her employment application, Chavarria had to agree to Ralph's arbitration policy. Although the application didn't include the policy, it contained a paragraph noticing applicants of it, along with an acknowledgment that the applicant was provided with the binding and mandatory policy for review. However, Chavarria wasn't given the 4-page policy until orientation, which was 3 weeks after she applied. The policy provided that one arbitrator would be selected to resolve a dispute, and that the arbitrator had to be a retired judge, but mustn't be from the Judicial Arbitration and Mediation Service or the American Arbitration Association, 2 institutions with well-established rules to ensure neutrality. The policy also set forth an arbitrator selection process whereby the non-initiating party selected the arbitrator. The policy's arbitration fees section required the fees to be apportioned when arbitration commenced and split evenly between Ralph's and the other party unless there was a Supreme Court ruling directly addressing the dispute issue and requiring different apportionment. The policy also provided that Ralph's could unilaterally modify it without noticing employees, and that their continued employment constituted acceptance of the new terms. Chavarria left Ralph's after 6 months and sued the store, alleging violations of California's labor code and other claims. Attempting to invoke its policy, Ralph's moved to compel arbitration. Finding the policy unconscionable and thus unenforceable, the court denied Ralph's motion, and Ralph's appealed to the Ninth Circuit.